Welcome back. It's the lawyer you know with another Kyle Rittenhouse trial update as the prosecution and the defense attorneys are both asking the judge to make some calls prior to trial so they can know what's in and what's out as far as evidence goes. Before every trial, lawyers file what's called motions in limine, and that's asking the judge to either limit the evidence or allow certain evidence and testimony in at the trial. And most of these decisions have to be made prior to trial so the lawyers can prepare what they're going to ask and tell the jury in voir dire, which is jury selection, and in their opening statements. Now, the judge can reserve ruling until a certain piece of evidence or certain testimony comes out as to allow these lawyers to proffer that evidence so the judge can see whether or not it's relevant and whether or not it's probative, going to prove some material fact, or if it's just prejudicial and not necessary for this trial. The first thing the state is asking the judge to keep out entirely or limit is the defense attorney's ability to call the victims or any other people that were around on August 25th of 2020 when these shootings happened in Kenosha, to refrain from calling them looters, rioters, protesters, arsonists, or any other negative term that has some negative connotation as to the reason for them being there, as to not gain sympathy or gain some kind of reaction from the jury to think that these were justified shootings based on those types of terms or words or actions that may or may not be true as the August 25th shooting occurred. They don't want to poison the jury. They don't want to be prejudicial or allow the defense attorney to be prejudicial when speaking about these defendants. The judge has not ruled on this yet. A lot of this stuff will be decided in the October 25th hearing, which is happening next week prior to the November 1st trial date, which is when it is supposed to start. So all of this should be determined by October 25th. So we don't know whether the judge is going to allow the defense attorneys to call them looters, rioters, arsonists, protesters, whatever it may be. So that's still up in the air. And this is not an uncommon argument in these types of cases. We have had cases where we have tried to keep the prosecutors from using certain terms and they have tried to keep us from using certain terms. Terms like criminals, convicted felons, drug dealers, terrorists, the word terrorism, bomb, explosives, all sorts of things that are buzzwords that elicit some kind of feeling and reaction from a jury that lawyers lots of times don't want to be elicited from a jury. So we ask the judge to limit those terms as they're not necessary in a lot of these cases to get the points across that you need to argue as a lawyer. So we'll see if it works in this case, or if the judge thinks that's fair game, they're allowed to call those victims those names or the people that were around those terms. We'll see what the judge says on October 25th. The second thing the prosecutors are asking for in this case is for all of the male adults involved, including and most importantly the defendant Kyle Rittenhouse, Mr. and then whatever their last name is. Not refer to them by first name, not refer to them as a kid, not refer to them as a minor, as to not elicit any sympathy from the jury. Don't call him Kyle, don't call him the kid, don't call him anything like that. Just call him Mr. Rittenhouse, and it'll apply to all the victims and all the other male adults in the case, again, as to not elicit sympathy to or for the defendant. That's common in every case. Judges usually don't like the use of first names. They usually don't like the use of first names for any witnesses, any parties, or even the lawyers. They can't say, oh, Peter over there had a good argument. Instead, they would say, Mr. Tragos, or the defense attorney said, and that's just kind of normal course of business in the courtroom. And they're just making it a point to say, Judge, we have a feeling they're going to try to elicit this sympathy by calling him Kyle. We want to put an end to it right now. So they're asking the judge to let them know before the trial even starts that is not going to happen. We'll see what the judge says. The third thing that the prosecution is asking for in this case is to not refer to one of the victims, Mr. Rosenbaum, as a convicted felon, as a child molester, as a pedophile, as a sex offender, any of those negative terms revolving the felony he was convicted of, which had to do with child molestation. They don't want any of that brought out in this case because they don't want the jury to see this as a justified killing, that Kyle Rittenhouse got a pedophile off the street by shooting him. It's not okay. You can't go shooting pedophiles. You can't go shooting sex offenders. You can't go shooting convicted felons just because you want to. And they don't want the jury to mistakenly believe that or think that somebody's arguing that. So they don't want any discussion about him being a convicted felon because of some kind of child molestation. Now, I think that the judge probably will limit what the defense attorneys can say about his felony conviction, But I absolutely believe that it is going to come into evidence that Rosenbaum is a convicted felon. That is fair game in every trial for every victim, every witness, and every defendant. If you have prior felony convictions, that is something usually that can come out, and that is admissible. Now, usually it's admissible to show bias. This person's a felon. Can you really believe what they say? So in this case, maybe they try to get around that. I believe that the fact that he is a felon, a convicted felon, will come out, but the judge may limit the fact that it has to do with child molestation as to not, again, make the jury think that Kyle Rittenhouse was justified in getting a pedophile off the street or something like that. So we'll see if that's limited. Now, the last thing that the prosecutors ask for is going to be the bulk of our discussion in today's video. They don't want the defense to have any mention or discussion about any of the civil lawsuits that are being filed surrounding this shooting on August 25th of 2020, because Gage Grosskreutz has filed a lawsuit. And in this lawsuit, it's not just against Kyle Rittenhouse. He is actually indicting all of the government entities involved in this case. He is saying that they aided in the white supremacy and aided in the armed militia coming to shoot protesters and to shoot minorities because of these protests and because of everything that was going on in Kenosha at the time. He has actually named in the lawsuit the city, the county, the police chief, the sheriff, the former police chief, all of Kenosha, in this lawsuit basically suing the entire government, saying they enabled and aided in the shootings on August 25th. I'm going to read some quotes from that lawsuit here just so you can see how, to me, it seems outlandish and kind of crazy to put this in a lawsuit and to put this out there. But you guys let me know. Do you think he's got a leg to stand on suing the entire government for what happened on August 25th, not just Kyle Rittenhouse? After I read some of these quotes, at the end of the video, I'm going to talk about how this civil lawsuit could affect the criminal case and why the prosecution is the one wanting to limit any discussion of these federal lawsuits. So I'm just going to hit some buzzwords, some quotes that I'm pulling from the complaint just to give you kind of the tone of this lawsuit and this complaint. First, he says the sheriff's deputies deputized a band of white nationalist vigilantes the night of August 25th. He called Rittenhouse's actions a natural consequence of law enforcement's decisions that night. The beginning of the complaint starts by quoting one of the officers in a video saying, as they walked past a group of armed men that included Rittenhouse, quote, "We appreciate you guys, we really do." They also talk about a Facebook post and account that solicited patriots willing to take up arms and defend our city tonight against the evil thugs. Now, Kyle Rittenhouse has already talked about how he didn't come through that Facebook group. He went with a friend. He didn't know about that Facebook group. Nobody from the police force in Kenosha asked him to come out. He didn't get solicited by anyone from the police chief to the sheriff to anybody else or none of these governmental entities, but they are still pushing to get this information in. I'll read a couple more quotes. Quote, "It was not a mistake that Kyle Rittenhouse would kill 2 people and maim a third on that evening. It was a natural consequence of the actions the Kenosha Police Department and Kenosha Sheriff's Office in deputizing a roving militia to protect property and assist in maintaining order. The defendant's open support of and coordination with the armed individuals in the minutes and hours before the shootings deprived Anthony Huber and the other protesters of the basic protections typically provided by police. It was a license for the armed individuals to wreak havoc and inflict injury." Now, those are some inflammatory statements. Those are some quotes from the lawsuit just to show exactly how they're coming. Sounds horrible, right? But it should be recognized that these lawyers have filed similar suits and most of them have been dismissed by a judge in this jurisdiction already. The only one that continued past that motion to dismiss was the First Amendment retaliation and violation of equal protection against the city that are potentially going forward. That didn't stop them from trying again with Gage Grosskreutz as a victim in this civil lawsuit that they have filed in federal court. So we'll see what happens. Additionally, these lawyers were asked about the fact that their client was armed as he approached Kyle Rittenhouse. Did they want to make a comment about that? And not surprisingly, they had no comment about their client being armed as this self-defense trial is about to start for Kyle Rittenhouse. So in my thinking, these civil lawsuits are actually good for the defense. If the country is thinking that the government was behind Kyle Rittenhouse, that the police enabled or agreed with what he was doing and maybe even solicited what he was doing, how can it be criminal? The police needed the help of these armed militia, and Kyle Rittenhouse was there to help. And these rioters and protesters and thugs were so dangerous that they needed the help. To me, that adds to the defense. That adds to the opportunity for Kyle Rittenhouse to argue self-defense, argue justified killing. So I agree with the prosecution that I would not want any mention of these lawsuits to come in, because it looks like Kyle Rittenhouse may be able to point the finger elsewhere, or he may have misunderstood, just as a layperson and not a law enforcement officer, he may have misunderstood exactly what law enforcement, what the sheriff, what the police chief, what the government in Kenosha was asking of this armed militia. And it could affect his mens rea. Did he know what he was doing was wrong? Did he know what he was doing was his own choice? Was it intentional? Was it planned to kill these people? Or was he just reacting? Was he not trained properly? Was he under the guise of some governmental direction? I think it just muddies the water of a criminal case. I think if they were smart and they wanted to get him convicted, these civil lawsuits should have waited until after the trial was over, but they didn't, and we're dealing with them now. So if talks of these civil lawsuits are allowed in the criminal trial, we'll see how it comes out. The prosecution thinks it's going to be a cause for a mistrial. There's going to create appellate issues. There's going to be all these things overhanging and intertwined in these two cases that are going to create so many problems in the criminal case, and I tend to agree with them. But you better believe, in jury selection, as they're going through one by one, talking about whether or not anybody's heard about this case, or if they already have an opinion about this case, a lot of that discussion is going to surround these civil lawsuits from the victims that Kyle Rittenhouse shot. If anybody followed the R. Kelly trial like we did, there was a lot of discussion about civil lawsuits trying to go after money, which painted some of the victims in a bad picture, but also showed that they were actually coming after R. Kelly, coming after the defendant in these cases. So I don't know how it would affect Kyle Rittenhouse that they're suing everybody, including the local government officials, in what happened on August 25th of 2020. Let me know what you guys think about those lawsuits, how you think they'll affect the criminal case, and whether or not you think these victims have an actual legal, successful cause of action against the sheriff, the police chief, the local government officials of Kenosha for the shootings that were done on August 25th of 2020. Let me know in the comments. And as always, if you like this content, don't forget to subscribe to our page and like this video. If you're interested in Kyle Rittenhouse specifically, liking the video lets us know that you want us to do more content about this case. I'm sure we'll do a follow-up after that October 25th hearing, and we'll do more follow-up as the trial begins. But make sure you get your questions in. I'll try to answer some in our next video so we can have you up to date and ready for the beginning of this trial. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.